The topic for this video is immigration appeals. A large number of immigration decisions are challenged in the courts. The court in this case is an immigration tribunal, which is a specialized tribunal. The full name of the tribunal to start with would be, at the first stage, First Tier Tribunal of the Immigration and Asylum Chamber. These courts, or rather the tribunals, are located in various cities in UK. There is none overseas. Previously, there was an option to file the appeals overseas and the embassies would send it to the tribunal themselves. Now you have to file it with the tribunal directly. You can do it by post, by fax, or recently they have introduced an online appeal filing. Appeals can be from people from overseas or from people who are in country. So that's how we distinguish between out of country appeals and in country appeals. The procedure is more or less the same, except that in case of out of country appeals, the appellant would not be here to represent his appeal or to attend at his appeal hearing. So most of the appeals that come from overseas are paper appeals. That is, they just do the appeal on papers and attach documents and send it to the tribunal here, and a judge would look at it on papers only in his office and decide without there being a hearing, no representatives, no witnesses, nothing, just on papers. But people do contest their overseas appeals completely, even without the presence of the appellant. Like, there will be your representative or sponsor and the Home Office lawyer and the judge, and there will be a full hearing. The other difference between in-country and out-of-country is that for out-of-country the time for filing is a little more, like 28 days against 10 days for in-country appeals. Then the wait is longer. The hearing will be, say, about 6-7 months from the date of filing of the appeal, while in country appeals you can get a hearing anywhere between 2 to 6 months. It used to be even shorter, but nowadays, due to rush of work, the appeals are taking a little longer to get heard. Another difference for out-of-country appeals is that whenever an appeal is filed, as a matter of policy, the Home Office requires the embassies to review the case. They will look at the new information provided in the appeals, like any new explanations, any arguments, any new documents. If by this new explanation or new documents they are now satisfied, then they can, instead of fighting the case in appeal or defending the case before the tribunal, they would simply grant the visa and finish the matter off at their own stage, make a phone call or an email to the appellant and ask him to provide his passport again, and they would stamp the visa and give it back. So this is a shorter say option if one is lucky enough. The balance procedure, as I would now proceed to, is common with both the out-of-country and in-country appeals. The setup is such that the appeals, when they are received at the main centralized center here in the UK, they take about 1 to 2 weeks to log in the appeals into the system, and then they issue notices, say 3 to 4 weeks from the date of filing. And the notices will also have directions for in-country appeals, and for out-of-country appeals they would only issue a notice informing of a pending appeal to the embassy and a copy to the appellant. They won't issue the directions or date of hearing straight away, but for the in-country appeals they would issue the date of hearing and the directions straight away in the first notice. The directions, when issued for the out-of-country appeals, would more or less the same as for the in-country appeals. They would require you to provide your witness statements in writing. Any witnesses who want to be present at the hearing and give evidence, they will have to give a written witness statement before the hearing. The deadline given in the directions nowadays is 3 weeks from the date of notice. Sometimes the notice fixes the date of hearing as 3 or 4 months from the date of the hearing notice, but still requires you to file the paperwork within 3 weeks of the issue of the notice. That is well before the date of hearing. What else is required in the directions is that you provide a bundle of all documents indexed, page numbered properly, so that a judge and the other users can usefully have a look at it with some ease. Normally your solicitor or representative would understand how to make a good bundle, how to do the page numbering, what documents to include, what documents not to include, and how to draw a proper witness statement, what matters should be discussed in the witness statements, what matters should not be. But in any case, a lot of people would do these things themselves. Sometimes the judges would give a little, say, leeway to those acting in person. When the hearing comes, the setup is such that the appellant, if it's in country, if he's here, he will appear as a witness in his own case, and also as an appellant he will bring in some witnesses like a sponsor if there is any, and any other persons who can give evidence to prove whatever he asserts in the appeal. Then there will be a representative from your side, from the appellant side, if they have chosen to appoint one. He can be a solicitor, he can be an immigration advisor, he can be a barrister. Generally barristers are instructed through the solicitor, so some people would have a solicitor as well as a barrister to represent at the appeal hearing. On the other hand, the Home Office will have an in-house employee of theirs called a presenting officer. He may not necessarily be a lawyer, generally they are not. Sometimes they also have barristers to cover up when they have too much of cases, or it's an important case and they want a barrister to represent them for a tricky case like asylum cases, and sometimes where there's a law point involved and they think it's of wider implication, they would also have barristers representing them. The appeal proceeds in a manner that at the start, at the hearing, the judge will introduce himself and say a little about the process that is going to follow on the day of the hearing. There will be only one hearing. It's rare that you have more than one hearings. Everything has to be settled on that day, say in half an hour, 1 hour, or sometimes longer, especially in case of asylum appeals, or where there are a number of witnesses. Generally there are 1, 2 witnesses, but sometimes there are 3, 4, 5 as well. Sometimes it's a very intricate case, but they tend to complete a case on the same day, so it doesn't linger on for months or years. It is decided once it is at the hearing, it is decided on the same day, though the decision may be delivered later on. So what happens to start with, the judge would have already read the evidence and the bundle and whatever you've provided, all the documents. The Home Office lawyer would have read it, your representative would have read it, so they can proceed with sometimes only the issues which are still to be resolved. Some of the issues might have been settled by then the Home Office lawyer after reading your evidence and bundle of documents, may not have issues with some of the points and drop some of the points and only focus on the real issue, 1 or 2 which are still left to be decided upon. So the first part of the hearing is the evidence. The written evidence, written witness statements and documents is already there. The only thing is that the witnesses have to be cross-examined by the other side. Generally the Home Office would not have any witnesses, only the applicants who are now the appellants, they would have witnesses, either only themselves as the witness or some other people. So since there are witnesses from your side, the appellant side, the Home Office lawyer will have the right to cross-examine you, so as to tell the judge that this witness is not reliable, whatever he is telling is not true, or whatever he is telling is not credible enough that you should accept that. So it should be disregarded, and only the uh, facts as proven by documents should only be uh, considered as evidence, and the matter should be decided accordingly. So at the inception, after a brief introduction, the appellant, who is also the witness, he is cross-examined by the uh, Home Office lawyers. Sometimes before that cross-examination, your lawyer would still say, "Oh, I need to add something to whatever is in the witness statement." So while he will ask you to confirm and adopt your written witness statement, he would also ask you a couple of supplementary questions, that they are in addition to what you have already said. They are sometimes important points that have been missed out, important facts that he would still want you to say, so that that can also be included in the evidence in deciding the case. So after that, the Home Office lawyer will ask questions. Sometimes they can ask a number of questions to confuse you, a number of issues wherever they would want to uh, confuse you or trap you, and sometimes people would say so much and give so much information which is not already there, that the Home Office presenting officer would have more information to ask more questions. After he has asked questions, the judge may also ask some questions to clarify and understand the issues. So after these question answers, your own lawyer, your own solicitor will have the opportunity to re-examine you. That is, he can ask you further questions, and the purpose of those further questions would be to clarify whatever confusion has arisen out of those questioning by or cross examination. So he tries to clarify wherever he thinks that you have not done well or not answered well. He would ask questions so as to get information from you in full, so as to clarify a matter. If there are any contradictions, he would try to resolve them by asking you more questions. After this, the evidence is closed, then the Home Office lawyer will present his case. He will argue and defend the refusal or whatever decision has been challenged. He would say the decision is correct, there is no error in it, there is nothing wrong with that, or if there is something wrong, it is minor, the result would still be that the visa or application should be refused, or whatever decision, it should be withheld. The judge may also ask him some questions to fully understand the submissions, and wherever he is confused or not clear, he would ask further questions. After that, it's the turn of the appellant through his representative, if he has one. So the representative would then present his case. He will argue why the decision is wrong, why the decision should be cancelled and leave or a visa should be granted. He would also deal with the mess, if any, that has been created out of the cross-examination and questioning of the witnesses, and try to cover and explain why there have been contradiction. There is a reason why there was something wrong with something, and he will say present a more explanation about the grounds of appeal that were filed with the appeal. Sometimes they would also present written skeleton arguments. Skeleton arguments would be very brief, as so you would understand by the word skeleton. Whenever you have a barrister, they would tend to always file skeleton arguments. So after the representative has completed his arguments, then the judge may ask him something to clarify things. He may even discuss the case with both the representatives to fully understand, and so that he has all the necessary information. And sometimes, if it is a very brief matter, very straightforward, and he is very clear on it, the judge may announce the judgment there and then. But obviously the legal judgment, the one that the Home Office can implement, is the written one. the written one would be available in 2 weeks' time. Sometimes the judge would not give a judgment there and then. He would not announce anything. He would simply say that I've had enough of information, I've got loads of documents to study, I've got papers and points noted down, I need to think over it, and I will give a decision in about 2 weeks' time. So once a decision is announced, the first stage of the appeal is finished. If the decision is in your favor, then if the Home Office doesn't like it, they can challenge it by way of an application for permission to appeal it further. If they do not appeal, then they have to implement the decision. All you need to do is to then wait for the implementation. On the other hand, if the appeal is decided against you and you want to challenge it further, you can do that within 5 working days of the deemed date of receipt of the decision, and you have to make a permission to appeal application, or PTA as we call it, in which you have to demonstrate that there has been an error of law by the judge in deciding the matter, and because of that error of law the decision should have been different. If permission is granted, if the judge granting permission thinks that there is arguably an error of law, he doesn't give a conclusive verdict. He simply says yes, this case should be allowed to be appealed for the second time before the upper tribunal because arguably there is an error of law. If he refuses to grant permission, then he is the first year tribunal judge. He is the first year tribunal judge, not necessarily the same judge. So if he doesn't allow permission, then you can make a direct application to the upper tribunal, and the upper tribunal judge would then have a look. If he thinks there is an error of law, he would grant permission and then the case would proceed. If he doesn't grant permission, then the matter ends. There can be no further appeals. All you can do is file a judicial review in the High Court against the order of the tribunal whereby they have refused to grant you permission. It is rare, very difficult for you to succeed in that thing before the High Court, unless there is something very extraordinary. The High Court would not be inclined to interfere in the matter. So if the case proceeds to the upper tribunal for a hearing, in the first part of the hearing, the judge has to decide conclusively now, not arguably, but conclusively that there has been an error of law. If he thinks there is an error of law and he decides that yes, there is one, and also that the error has been a material one, because of this error the judgment would have been different. So if he decides so, then he will cancel the order of the first year tribunal and remake the order. Now it is for him either to do all the process once again with the witnesses and evidence and arguments, everything, or if it is a short matter or a technical matter, he would decide the matter there and then, soon after the first part, and he would decide whether to allow the appeal or to dismiss the appeal. So after he has decided the matter, it can be taken further to the Court of Appeal. Either the Home Office would challenge it, or if you have lost, you may challenge it, or sometimes no one would challenge it because it's very costly and difficult to fight it further. The permission is very difficult at the Court of Appeal stage. Now you would have to prove something more than just an error of law. You have to demonstrate that the judge of the upper tribunal has erred in law, plus that there is one of the two things. Number one is there is a matter of public importance involved in it, like whatever point was decided is of wider implication. It may affect another 100 or another 1,000 of other appellants or applicants. It's a point of wider implication, or there are legally compelling issues. If that order is allowed to remain on the case law, it would be detrimental. It's a wrong decision. The principles decided are wrong. So you have to demonstrate one of those two things, and the application for permission to appeal goes to the upper tribunal in the first instance, If they grant permission, it goes to the Court of Appeal for a hearing. If they don't grant permission, then you have the option to make an application directly to the Court of Appeal, firstly on papers only, where the judge would decide whether there is an error of law and whether there is a matter of public importance or a legally compelling reason. And if he decides that yes, there is a situation where permission should be granted, then they will fix the case for a full hearing. If he decides no, there is nothing like that, then you have a third chance. You can apply to the Court of Appeal for an oral hearing of the permission application. You send your barrister to the Court of Appeal, and the Court of Appeal judge would hear your barrister explain how there is an error of law and how it is material and how there is a matter of public importance or how there are legally compelling circumstances. If they grant permission, then the case proceeds to a full hearing later on, not necessarily, generally not on the same day. It will be listed for a full hearing. So after the Court of Appeal, there is the Supreme Court, which it is very rare, very difficult that you can take it to the Supreme Court. The threshold is very high, permission is granted with great difficulty, but cases do go to the Supreme Court. And even after the Supreme Court, there is the chance of going to the European Court of Human Rights. So if it involves human rights, so that would be the final order. But very few cases will go to the European Court of Human Rights, and very few cases will go to the Supreme Court. So the process is more or less ended generally at the first tier tribunal stage, and some cases will go to the upper tribunal and very few will go further up. So the process in appeal is quite tough. The first appeal before the first tier tribunal is the most important. If you mess up at that stage, then it becomes very difficult in getting it reversed at the higher forums, because the higher forums are not are not interested in all the factual controversies. They tend to interfere only when there are legal things and the case is legally incorrectly decided. So you have to fight out your appeals very well, professionally, preferably with the help of legally qualified persons like solicitors and barristers. Barristers are generally more used at the stage of the Court of Appeal. With the first tier tribunal and the upper tribunal, your solicitors who are also advocate and who would appear at the tribunal stage on a routine basis may also be good enough for representing you properly. If they have prepared the case and they are again representing you, so they have a better grip over the case rather than engaging a barrister at that stage. But sometimes there are important cases, there are legal points where you need a barrister to present the case very, very professionally and add something to what the solicitors have already researched. So it has to be fought well, and if you have an appeal, I wish you good luck with your appeal. Thank you very much.